What you are about to see may revolutionize your practice. It will change the way that you think about what you do. It will change the way that you present your case in court. And it will change the lives of everyone that affects you. If that does not suck you in, then you are dead. As Robert Greenspan said, happiness is not a reward, it's a consequence. Suffering is not a punishment, it is a result. And we deal in suffering. Our job is to effectively present to judges evidence that truly reflects our client's plight. Our panel today will show you two different ways to effectively do just that. One is a how-to sorts, showing you how, through the use of expert testimony, how to establish permanent disability. And for that, our speakers are Rob Pearman. Rob is a former skiff adjuster who has practiced for 12 years. He is a certified specialist out of Van Nuys. He is the treasurer of the Los Angeles Valley Applicants Association. He is the president-elect of the San Fernando Valley Bar Association. And he has the best parties in the city of Los Angeles.
That's whole person impairment.
However, his estate is earning money. What now? Go ahead.
Well, thanks, Russ. Yeah, if Tupac's dead and he's still making money, is he 100% disabled? Well, our current standard of 100% disability under the new schedule is total loss of future earning capacity. And this is our topic tonight. I think it's one of the most difficult topics to do because it touches almost every aspect of workers' compensation law. Now, in my handout, I've provided you with 35 cases over the last 2.5 years that cover vocational expert cases and 100% cases. And an analysis of these cases will show that you must know the following to make an effective use of a vocational expert. You must know the AMA guides. You must know the new rating schedule. You must know the old rating schedule and the work restrictions. You have to know the rules on psych cases. Apportionment is huge on this topic. You need to know the subsequent injury fund. The trial discovery issues, you need to know substantial evidence, Alvarez Guzman 2, Ogilvy 2, utilization review, MPN, and cost per 5811. If you misjudge any one of these categories, it could jeopardize your ability to get 100% on your case. So let's start with costs. Now, if you have 30 or 40 cases where you're using a vocational expert and the retainer is $1,500 a piece, costs become pretty important. They add up pretty quick. Now, costs are allowable under the Costas case and Labor Code Section 5811. If you turn to page 4 and 5 of my handout, you'll see that I gave you the three costs. I gave you the cases following the Costa case. And these cases stand for the proposition that your expert should get paid if their opinion is substantial evidence. Now, let's go to page 6. This is my ex parte petition in order for costs. Most judges will sign this. So as soon as you pay the retainer, you can go into court, have the judge sign it. It's got a self-destruct provision. But what if the defendants still aren't paying your costs? What are you going to do? Well, go to page 9. This is my petition for bad faith actions or tactics pursuant to Labor Code Section 5813. Now, this is a petition that I used to use for 5710 fees, and I found a case that extends this to vocational costs, and that case is the Malmuth case, and I gave it to you guys. It's on page 13. What Malmuth says is that 5813 sanctions apply for the unreasonable refusal to pay 5811 costs of vocational experts. Now, Malmuth didn't get it, but this case says that you can use that code section. This means that you can get attorney's fees for all of your time and effort that you spend collecting these costs, for preparing the petition, for driving to the Workers' Compensation Appeals Board. Ladies and gentlemen, if the defense gets costs, we have to get our costs, okay, for vocational experts. Let's move on. Why do you need a vocational expert? Well, first of all, most doctors are not trained to assess employability and placement in the job market. Let's look at the next reason, which is on page 2 of my handout, if you wouldn't mind flipping back. And this is the 2005 rating schedule. And so if you look at the, if you turn, so it's at the right angle, and you look at the bottom right-hand side of this, you'll see the 100%. Well, it takes, if you have 99% disability, it takes a whole nother 50% to get to the 100% disability. Let's look at the next page. In this part of the rating manual, you'll see that a 93% permanent disability, you need to combine that with another 93% permanent disability in order to get 100%. So you almost need 2 people under our rating manual. I mean, this is almost impossible. In all of the cases that you have, there is going to be a gap between your final permanent disability rating and your 100% case. And your job as applicant attorneys is to fill in that gap. So, let's talk about some of the different ways that you can do that. Start with the vocational expert. A vocational expert ties in the doctor's opinions, the psych, the internal, the ortho, together with the work restrictions, the affected activities of daily living, the subjective complaints, and he paints a picture of the whole claim, of the specific circumstances faced by this person, their transferable skills, as pitted against the entire job market. Now, effective use of a vocational expert is not something that you just do at the end of the case. This is a process that starts at the beginning of the case and continues through the duration of the case. It's even in effect after the case has been submitted for decision, because you may need to cross-examine the rater and use a vocational expert for that. So, a vocational expert is not always going to fill in the gap for you to get your 100% case. What else do you need? Well, you must consider the multi-specialty approach that is delineated in the ACOM guidelines. So what does that mean? Well, let's look at the Hertz case. Now, I didn't include it in my materials, but I paid close attention to the section that we just heard from, and I look at the Hertz case a little differently. Here's the facts of Hertz as I see it. Now, we heard last time, this guy was 47 years old, he worked 17 years, 80 hours a week. But listen to this, he had chronic pain in both his upper and lower extremities. He was post-surgical. He couldn't return to his usual and customary job. 2 vocational experts agreed that this person could never work again. What's missing? Where was the psych? We're talking about the multi-specialty approach. Why wasn't that filed on this case? Did anyone think to ask Mr. Aguilar if any of these things bothered him? Now, I don't mean to be controversial. I have a lot of respect for all of the people working on things. I wish them well in their appeal to the California Supreme Court. But I think it's very important in using vocational experts that you have your case set up from the very beginning. We've all heard about the multi-specialty approach in the ACOM guidelines. It's critical on these 100% cases. The vast majority of cases in my handout, you will see if you do not file a psych on the case, you're not going to get your 100% award. Now, as kind of an aside on psych, I don't think you should file a psych at the beginning of a case unless it's like a horrific injury. I think if you do this, you lose credibility. I think it puts the insurance companies on the defensive. And also at that point, the client is still optimistic that the treatment's going to make him better.
Excuse me, Rob, take a breath.
Just for one second. Sorry.
Uh-oh, what happened? Did I...
Ted Richards, partners, are they in the room? They need to go out front. Mr. Richards is being taken away. So if his partners are in the room, they need to go out front.
Can I continue? Go ahead. All right. We were talking about psych cases. Take it away. Oh, shit.
The mic is on.
Well, no, I hope Mr. Richards is okay. All right. So at the beginning of the case, the client's still optimistic. It takes a while for the client to start losing hope and develop psychiatric symptoms. And this means that during the case, you need to talk to your client and you need to ask him, is everything okay? How are you feeling? Because I don't think a doctor always thinks to ask. The judge in Hertz, he wanted to give him the 100% award, but he couldn't. The applicant ended up getting a 60%, which is about $51,000 for 2002 date of injury. The vocational experts in Hertz were not able to close the gap between the 60% and their hopeful 100% award. So what would psych have done in that case? Well, let's look. If you have a slight psych, and say it comes out to be a 25% standard, and you MDT that, this is an old schedule case, with a 60, you get a 73. Well, if your case is in the 70s, if you use a vocational expert, you kind of have an outside chance of getting your 100% award. Now, what if it's a moderate psych? Say it adds 40. If you have a 40% psych, MDT with a 60%, then you get 80. Now, when you're in the 80s with your permanent disability rating, then you got a fighting chance using a vocational expert to get your 100% award. Let's go to page 48 of my handout, please. This is the Parodies case. In Parodies, a vocational expert testified that the applicant was 100% disabled. The orthopedic AME agreed that the client was 100% disabled. However, the orthopedic AME apportioned 10% to non-industrial factors, whatever those were. The workers' compensation judge was reversed for not apportioning 10% off the 100% award. So the applicant ended up getting a 90% award. Well, again, no psych. Why wasn't that filed? Would psych have made a difference? I think when you're looking at vocational experts, there's two different types of jobs in the job market. There's physical jobs and there's mental jobs. So if you only have physical restrictions, I think there's an inference that you could still go out and do a mental job. Now, if you have both physical and mental restrictions, then you'd be considered to be 100% in many cases. In all of these cases that I'm providing you, I looked at this, first of all, let me digress. It's important on all these cases to get your evidence. Your evidence isn't going to just fall out of the sky. Evidence is something that you have to take. Now, let me give you an example. What if you're, after talking to your client, the client needs a referral from his treating doctor, and it's an MPN doctor, but the doctor won't do it, or the insurance company, you've heard this, they're denying the referral. You know, you need to know how to get out of the MPN. What about a UR denial? Same thing, you need to know how to deal with that, because you can't let this type of thing affect your 100% case. You just can't do it. Another concept that I'm seeing in this line of cases that I've provided to you is that, and I'm also seeing it in defendant's vocational expert reports, is that no doctor said that this applicant was 100% disabled. Now remember, we need to prove that both the applicant was 100% disabled and that it was caused by work. So here's a tactic, here's an idea for you. Say you have a case where you have psych, ortho, and internal. You go to an AME on the psych and the ortho, But you don't do it on the internal. You hold that back. And you rely on your treating internist. Well, here, that way, you could perhaps get an opinion from the treating internist that the applicant is 100%. You can even send your vocational expert report to the treating internist, and maybe he'll adopt and incorporate it. Now, I think that internal medicine is a good specialty to do this with because of the internist's familiarity with medications, with pain, with how stress affects the body. And he's able to determine a person's tolerances with respect to returning to work. Let's look at some good results. Go to page 31, if you would. This is the Perez case. This is Jamie Berenson's case. She lectured about this at last summer's CAW convention. If you didn't go, you should try to get the syllabus for this material and look at what she put in there. This case shows a masterful use of vocational experts, the multi-specialty approach, the applicable law. The court held that LaBeouf applies to new schedule cases, and the court held that according to Labor Code Section 4662, that the applicant was 100% disabled in accordance with the fact. Now, if you're a defense attorney out there, and you see on the steps and issues, among other things, Labor Code Section 4662, are you going to know what that means? Oh, the opposing counsel on Jamie's case, I don't think we'll ever forget it. I guess we're going to talk about, let's go to page 27. The Cornu case. I didn't know they were going to do this in the most important cases, but I want to just make a couple quick comments about it. On the date of injury, there was one date of injury. It's an old schedule case. The orthopedic AME, Dr. Angerman, gave significant restrictions. The psych AME, Preston, gave his permanent disability, but 40% was non-industrial and 60% was industrial. The MDT of this was 96%. Here, a vocational expert was successful in filling in the 4% gap between the 96% and the 100%. Another thing that I'm seeing using these vocational experts is the phrase that the applicant wasn't motivated to return to work. I've seen it used in these cases as a rationale for denying 100% cases. I've seen it in psychiatric reports. I've seen it in defense vocational expert reports. And it's kind of insulting. These people who have horrific injuries are saying, well, they're just not motivated. Well, I think there's a point here that you need to get your clients to show a positive attitude, to be kind of open-minded. Sometimes people do go back to work. I think there's an inference that there's a duty to mitigate in this system. And you can't sit back and just say, well, I've been injured. That's the way it is. And so you need to encourage your clients to attempt to look for jobs. And as you're doing this, have them track their positions, where they went, who the contact was, the address, the date that they went, and keep a log of this. And if they still can't go back to work, provide that information to your vocational expert so it'll bolster their testimony. Okay? On pages 58 to 72 of my materials, I deal with substantial evidence. The courts let the AME doctors that exist on a case develop the record per McDuffie. But they don't let you do that with vocational experts. At trial, it's a pass-fail test. So you need to make sure that you send your vocational experts all of the pertinent medical evidence. I also send my vocational expert new schedule cases the Ogilvy brief. Look at page 18. The Lopez case. Now, vocational experts use work restrictions and psychiatric protocols in their analysis. This is a DFEC case, pre-Ogilvy, but I think it provides an important element for using a vocational expert. And that is that your vocational expert must have an analysis of the AMA guides, of the whole person impairment. Same thing is true. You have to ask them if they're on the stand about the GAF. Doctor depositions. This is the final point before I get into my hypothetical. Work restrictions are used by vocational experts. So if you're at a doctor's deposition, even though it's a new schedule case, you still want to ask them about work restrictions. You're going to say, now doctor, this is a new schedule case, but I'd like to ask you about work restrictions. Shouldn't they be higher? Well, the doctor's saying, well, it's a new schedule case. Well, of course they should be higher. It's of no consequence. It's impairment. Well, the answer is it's of consequence to your vocational expert. You need to know your old schedule. Don't throw that book out. It's very important for these vocational experts. You even need to know the off-schedule restrictions. And so I think people who are new to the system need to be taught about those restrictions as well. Also, at the doctor's depositions, you need to set your vocational expert up for use at trial. You need to ask them, do you have any training in vocational placement? Oh, no, I don't. Well, if a vocational expert were to testify at trial and be found credible by a workers' compensation judge, would you defer to the vocational expert? Well, yes, I would. Well, doctors love to defer to other things, right? So you need to tie your vocational expert into your medical opinion. Let's go to page 76, if you would. This is my hypothetical. And this is an actual case I had. There's two AMEs, Dr. Stephen Bowerman, Dr. David Freeman, psych and ortho case. And their disabilities combine for 44% permanent disability. Well, that's quite a gap there. It's 44%. Can I get to 100? Well, first of all, you have to try to increase permanent disability. And so there's kind of a step-by-step process at that point, right? You look to Alvarez-Guzman 2, and then you look to Ogilvy 2. So let's go to page 78 and see what Ogilvy does. You're actually right in the middle of my Ogilvy trial brief. Now, Ogilvy in this case increased the award from 45 to 70. So that's pretty good, right? So I'm looking at this lady and I'm thinking, well, okay, but she's on Social Security, so one administrative body doesn't think she can work ever again, right? And she's got a lot of pre-existing conditions. I have a big box of her medical records. So I'm thinking, maybe I can do something. So I call up my treating doctor. If you'll go to page 86, and it's Dr. Padveen. And I tell Dr. Padveen, I said, Dr. Padveen, this lady has pre-existing bilateral knees, which are not included in the case in chief. Can you prepare a report directed to the subsequent injury fund? Well, he asked me, he said, well, was the pre-existing disability labor disabling? I said, yeah, it was. I said, there's subjective complaints, there's medical treatment in the records? Sure. So he says, okay, and he prepares this report, and that's what you're looking at, address the subsequent injury fund. Dr. Padveen evaluates the applicant's knees and reviews all the records. If you look at page 88, he finds pre-existing knee conditions back in 1983 to both knees. And then if you go to the end of his report, on page 105, Dr. Padveen provides 30% whole person impairment on each knee, 51% total, though we don't care about that. And so I did the ratings on this, and this increases the permanent disability to 86%. Now, remember, if you're in the 80s, you've got a fighting chance with the use of a vocational expert that you can get your 100% award. Of the 86%, it's important to know that 70% is industrial, and the difference between 71 and 86 is non-industrial or directed to the subsequent injury fund. Now, once I see that 86, I'm going to go out and I'm going to get a vocational expert. I'm going to see if this person can work anymore. So once I've done that, now I'm looking at 70% industrial and the difference between 70% and 100% for non-industrial subsequent injury fund benefits. So, things look pretty good. Let's look at page 106. In this case, Dr. Padveen reviews the ortho and psych AME. He has assessed the non-industrial pre-existing disability to the knees, and he renders, based on that, and as a treating doctor, that this person is 100% disabled. Remember the importance of that we talked about earlier? Now, on page 108, I gave you all of the 100% cases and vocational expert cases that pertain to the subsequent injury fund. You know, interestingly, no defense attorney has ever come up to me and said, I think maybe one, and said, hey, why don't you join the subsequent injury fund? Stop asking me for me more money when you should be getting it from the subsequent injury fund. You know, and yet they seem to almost kill each other joining other co-defendants. Why don't they ever ask for that chair to get filled, right? I don't know. All right. Let me throw a twist in this What? All right, I'll talk faster. Let me throw a twist in this hypothetical. The doctors go out and they get the defendants go out and they get a vocational expert to counter my Ogilvy petition. Their vocational expert says that this lady could have worked as a receptionist, making $21 an hour, and that my Ogilvy petition does not apply. According to him, I don't get 70%, I get 42%. Well, first of all, they looked at my trial brief and they said, okay, doesn't discovery close at the MSC, number one? Number two, isn't his opinion speculative if he's never even met my client? He's trying to do vocational placement with somebody he's never even met? She might have a positive attitude, right? The other thing is he's going against a medical opinion, and he is not qualified to do that. Dr. Padvey in this hypothetical said that this person cannot work. So I don't think there would be any probative value towards his testimony whatsoever. Now, looking at this, Ogilvy presents a range of evidence that you can settle within. I've been in judges' chambers where you can suggest to a judge kind of a happy medium in there. That's one way to do it. But of concern here with this defense vocational expert, remember, my subsequent injury fund case relies on that I need 35% industrial permanent disability in the case in chief before being adjusted for age and occupation, or I cannot pursue my SIF case. If I don't have an SIF case, I cannot use my vocational expert. You need a really good treating doctor. We talked about that on the last section. Let's go to page 109. The Gambito case. Gambito says that you cannot go out and get a QME of your choice under our new system. It's not admissible under 4062, 4062.2. If you're pursuing the subsequent injury fund, people, you can't just go out and shop for a QME. Because if the subsequent injury fund gets word of this Gambito case, they're going to move to exclude your evidence. So you need to use a treating doctor, and that's why a treating doctor is very important. You could also use a panel QME or an AME, but I haven't really had any dealings with them on that yet, on that basis yet. The last part of my materials contains the minutes of a hearing of a trial that I had using a vocational expert, which is also your next speaker here, Carmen Roman. Couple ideas: make sure your expert is subpoenaed. Also, if you don't use a vocational expert, you can always use a vocational expert for rebuttal, and you would file an objection in motion and strike the rating instructions to cross-examine the rater, to present rebuttal evidence of a vocational expert. You need to file a DOR with that. Direct examination at trial. Am I done?
2 minutes.
2 minutes, cool. At trial, you need to start with their qualifications, their education and experience. when they were retained, what materials they relied on, the depositions, reports, when they interviewed the client, their analysis, test calculations, work restrictions, ADLs, Pearman, GAF. And finally, you need to make sure that their opinion is based on
What you are about to see may revolutionize your practice. It will change the way that you think about what you do. It will change the way that you present your case in court. And it will change the lives of everyone that affects you. If that does not suck you in, then you are dead. As Robert Greenspan said, happiness is not a reward, it's a consequence. Suffering is not a punishment, it is a result. And we deal in suffering. Our job is to effectively present to judges evidence that truly reflects our client's plight. Our panel today will show you two different ways to effectively do just that. One is a how-to sorts, showing you how, through the use of expert testimony, how to establish permanent disability. And for that, our speakers are Rob Pearman. Rob is a former skiff adjuster who has practiced for 12 years. He is a certified specialist out of Van Nuys. He is the treasurer of the Los Angeles Valley Applicants Association. He is the president-elect of the San Fernando Valley Bar Association. And he has the best parties in the city of Los Angeles.
that's whole person impairment.
However, his estate is earning money. What now? Go ahead.
Well, thanks, Russ. If Tupac's dead and he's still making money, is he 100% disabled? Well, our current standard of 100% disability under the new schedule is total loss of future earning capacity. And this is our topic tonight. I think it's one of the most difficult topics to do because it touches almost every aspect of workers' compensation law. Now, in my handout,